Inventor'S Journal, we're going to learn what a patent is and why patents can be important to your research. The following video is part of the MIT Library's video tutorial series. This is part 1 in a 4-part series on patent searching basics.
In this video, we're going to give you a brief introduction on why you would want to search for patents and what a patent actually is. So why search the patent literature? It's been estimated that 85 to 90% of technical information in patents appears no place else. At MIT, we're used to a very scholarly environment where people publish journal articles on their research and are very open about sharing information. But in private companies where a lot of inventions are created, there isn't this incentive to share information, and the only place they're forced to disclose information about their technologies is when they file a patent. You may want to look at a patent to find out how something works. Because how technologies work is disclosed in patents, you can often find very nice diagrams explaining how a device works, and if you read the descriptions, there's very detailed information on exactly how that technology works. You may also want to search the patent literature to make sure an area of research you're working on hasn't already been done, and this can help avoid duplication. You may want to find information about what areas a company is doing research in, either because you're looking to apply for a job there, or maybe it's for competitive information because you're from a rival company. You can also identify experts in a field because you can look at the inventors of a technology. Companies also sometimes use what's coming out in the patent literature to identify new research fronts and/or licensing opportunities. Many of you who are listening to this video are probably interested, though, because you have an invention or a device that you're thinking about filing a patent for, and you want to make sure that nobody else has done this before. So what is a patent? A patent gives the owner exclusive rights over a technology, and generally that's a monopoly for about 20 years in the country in which the patent is issued. U.S. patents are granted by the U.S. Patent and Trademark Office, and most countries have their own patent offices. It's important to note that a patent in the U.S. only protects your invention within the U.S. Other people in other countries can use your technology without any legal recourse for you. If you want protection in those countries, you have to separately file patents in each of those countries. There is no worldwide patent. So clearly it's a strategic decision you have to make about which countries it's important to protect your invention in. So since 1790, when the U.S. Patent Office was established, it has awarded more than 7 million patents. Generally there are 3 types of patents. Utility patents are the most common. That usually involves a technology or device, but you can also get patents on the design, which is the look and feel of something, and you can also get plant patents, which you may have heard of someone getting a patent on a particular rose hybrid or a type of tomato. In order to be patentable, inventions have to meet 4 main criteria. First of all, your idea has to be novel, unique and new. There can't be any evidence of this idea being in the public domain anywhere before you filed your patent. It has to be non-obvious to someone skilled in the art, so an expert in the area wouldn't think, well, that's just too obvious. It also has to be useful, which seems intuitive, but actually if you look at some issued patents, you'd wonder what the examiners were thinking when they issued the patents. But in theory, yes, your invention has to have a useful purpose. And as mentioned before, in order to get a patent, you have to provide full disclosure of your technology and how it works. So from the time when you first apply for a patent to when it's issued is generally about 3 years. When you apply for a patent, you will have done a prior art search. This means that you've searched the published literature for any evidence that that your idea has already existed in the public domain somewhere. Obviously you're hoping that it doesn't, but you need to do this prior art search so that you don't waste a lot of time, effort, and money before finding out at the end that there is already technology developed in this area. An important thing to note too is that not everything is actually patented. There are certain things that have just been put out there in the public domain without anyone issuing a patent on it, just for the public good. So for instance, HTML, if you've ever used that for web coding, is just in the public domain. Nobody's gotten a patent on that technology. Also, some companies may decide to keep something a trade secret rather than get a patent on it. A patent is only good for 20 years, and if you want to keep that monopoly on that technology, you can actually, if you can keep that, how that technology works secret, you can do that indefinitely. An example of that is the formula for Coca-Cola. They've decided to keep that a trade secret instead of getting a patent on it.
If you're interested in viewing the rest of the video tutorials, use the links below. These videos were produced by MIT Libraries, and we use them under a Creative Commons license.